Deep. Very serious.
Hello, everyone. As expected, the post-trial motions filed by Donna Adelson's lawyers were all denied by Judge Everett. He didn't even feel necessary to ask the state to file a response. And often that's what happens when a motion for new trial is filed or a motion to interview a juror. The judge may rule on it just on the motion. If he finds that there is an insufficient basis alleged on the motion, he can just deny it. In this particular case, Judge Everett was actually quite nice. Not only did he deny the post-trial motions, but he actually explained his decision, his rulings, the basis for his rulings. So if you just want the short version of this video, it's very simple. The judge denied the request to interview two jurors who have spoken on social media about the case, and the judge denied the post-trial motions for new trial that Donna Adelson's counsel filed, not just for new trial, but also for judgment of acquittal. So all motions are denied. The judge gave nice explanations for his rulings. And so what I'm going to do is I'm going to read to you all the judge's order, which is excellent. And then I'll take some questions or give you some clarifications as needed. I may also give clarifications as I'm reading the order. So let's get started. Let's start with the beginning of the order. So it's called Order Denying Defendant's Post-Trial Motions. This cause came before the court for consideration of the defendant's motion for leave to interview jurors, motion for new trial, and renewed motion for judgment of acquittal, all filed on September 15, 2025. The court, having reviewed the defendant's motions, the court filed the trial record, and being duly advised in the premises, hereby finds as follows. Now, by the way, I did do a video. Ed did a reading of the motions filed by Donna, and I also did a video discussing my thoughts on the motion, and also predicted that everything would be denied, especially the issue of the jurors. There was an insufficient basis for a juror interview to happen based on the allegations in there. I also myself followed up with JC, whom I interviewed extensively, just to verify and confirm that nothing untoward happened, that nobody contacted her during the trial, anything of the sort. And she confirmed it. But as you'll see, the reason for the denial of the motion really has to do with the insufficiency of the allegations. So let's go ahead and read the order. Motion for leave to interview jurors. Defendant seeks to interview two members of the jury in her case, juror number 5 and number 7. In moving to interview jurors, the motion must set forth allegations that are not merely speculative, conclusory, or concern matters that inhere in the verdict itself. And I explained what that means previously. So if the allegation is that a juror maybe somehow misunderstood the evidence or misunderstood the jury instructions, that inheres in the verdict. Just because one juror may have misunderstood something is not enough to allow interview of a juror. And so it cites to the case Foster versus State. Consequently, open quotation marks, juror interviews are not permissible unless the moving party has made sworn allegations that, if true, would require the court to order a new trial because the alleged error was so fundamental and prejudicial as to vitiate the entire proceedings. Defendant's allegations do not establish a prima facie case of jury misconduct, but instead encourage the court to engage in a procedure disapproved of by the Florida Supreme Court in Smith versus State. The argued reason for interviewing juror number 5, and that's the male juror who gave a few interviews, is that he revealed that he considered how defendant Donna Adelson reacted to the evidence and testimony during the trial. However, Donna Adelson's attorney also noted that juror number 5 expressly stated that he did not consider her reactions during deliberations. Defendant's motion thus concedes that juror number 5 said he did not consider the defendant's reactions when deliberating. This challenge primarily concerns that juror number 5 observed defendant's reactions during the trial. By operation of fundamental procedural and statutory rights, the jurors are present in the same courtroom as the defendant. It is not impermissible for jurors to visually observe the defendant over the course of a trial. The Florida Supreme Court, in the case of Phillips versus State in 2010, found that the fact that 3 jurors briefly viewed the defendant in his jail uniform, for example, was insufficient to warrant a new trial. The facts alleged here fall short of the argued prejudice found as insufficient in the Phillips case. Accordingly, defendant may not have leave to interview juror number 5. Next, the judge talks about juror number 7, that's JC, the lady who was the foreperson who I interviewed extensively for over 2 hours. Anyway, let's talk about the judge's ruling about her. The judge writes, the argued reason for interviewing juror number 7 is that she posted on TikTok that she was selected as a juror on August 26, 2025. Defendant Donna Adelson provided a video recording of this post, and the court was also able to locate the post on the juror's TikTok account, where it remains an active post as of the filing of this order. And Judge Everett, says that expressly in here, that he was actually able to look at it on TikTok. The reason he says that is because Donna Adelson's motion actually says that this juror somehow deleted that post. And I actually checked with JC. I re-signed up for TikTok so that I could actually review it myself. And she said, I never deleted that, so I don't know what they're talking about. That's false. So the judge does point out here that he actually was able to view the post on TikTok. Anyway, it displays the following text over video of juror number 7. When I told God I needed a break and he makes it so, I am selected to serve on a jury for a 2-week trial. Won't he do it? Along with a caption that reads, no work, no kids, open parenthesis, for most of the day, close parenthesis. You know what? Heaven, yeah. So the judge obviously is quoting from JC's TikTok video. Then it goes on as something that we discussed when I did an analysis. I actually showed the jury instructions that Judge Everett gave to them as to what they can and cannot do. So Judge Everett writes, the jury was instructed not to communicate with anyone, including your fellow jurors, about this case. And that's italicized, emphasized, because that's the important part that I talked to you guys in my analysis about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any form of communication. The court concludes juror number 7's TikTok post does not constitute communication about the case. Rather, it was a comment about her jury service and its length. It does not reveal the parties, the attorneys, the alleged crimes, whether it was civil or criminal case, or even the location of the trial. In other words, it was not about the case. As such, it is not juror misconduct. The TikTok post was not so fundamental and prejudicial as to vitiate the entire proceedings. Furthermore, every prospective juror was informed, if you are picked for the jury, You may tell people that you have been selected for the jury and how long the case may take. However, you must not give anyone any information about the case itself or the people that are involved in the case. Defendant did not object to the jurors being able to disclose that limited information, and juror number 7's TikTok post comports with this exception to the communication prohibition. Defendant cannot now use juror number 7 compliance with this directive as grounds to interview her. Accordingly, defendant may not have leave to interview juror number 7, JC. The motion for leave to interview jurors is denied as to both jurors number 5 and number 7. So that's the issue of jurors. And I discussed it on my analysis, and I think that the judge's ruling goes exactly the way that I expected and that I thought it would go. I clearly indicated that actually there were questions from some of the jurors specifically about this issue, and the judge told me, yeah, you can tell your employer, for example, or your spouse, how long you're going to be on, serving as a juror. So again, as JC herself said, when people started to attack her, she complied exactly with the orders of the court. She didn't do anything that violated the judge's instructions. In fact, she did exactly as was allowed by Judge Everett. So good job, JC. I thought that our full interview with JC was really, really awesome and insightful, and I hope you guys check it on our channel. Should still be public. All right. I'm going to come back and talk to you guys and answer any questions, but for now, I'm just going through the order. So the next thing I'm going to do, and by the way, if anybody is curious about what I'm drinking mate. Is a drink from Argentina. It's kind of like a tea. You pour hot water in there, refill it. If you ever watch Messi pregame, you'll see him drinking some mate as well. So that's what I'm doing, drinking mate. M-A-T-E it's called. So there we go. Let me clear my throat with some mate and let's go. All right. Motion for new trial and renewed motion for judgment of acquittal. A, contrary to the law or the weight of the evidence and judgment of acquittal. So in this part, he's going to talk about the judgment for acquittal motion. The court does not find the jury's verdict is contrary to the law or the weight of the evidence. When considering a Rule 3.600A2 new trial motion based on weight of the evidence, the trial court must exercise its discretion to determine whether a greater amount of credible evidence supports an acquittal. The court must weigh the evidence and determine credibility just as a juror would. So they're basically asking him to serve as the 13th juror. The court relies upon its previous rulings, all direct and circumstantial evidence admitted, and the evidence demonstrating defendant's consciousness of guilt, and its own credibility determination of the witnesses. Stated succinctly, there is evidence in the record demonstrating overt actions by the defendant in furtherance of the murder for hire scheme. Any sides to the Denise Williams case? At a minimum, there must be proof of some overt act or some words uttered in furtherance of the scheme that led to the murder. The members of a conspiracy may have more than one objective. The trial evidence demonstrates the defendant's objective for the crimes being completed as separate and distinct from her son, the middle woman, and the triggerman. However, their combined acts resulted in the crimes committed and death of the victim. Because the objective of certain co-conspirators here was obtaining money through criminal acts, the death of the victim did not terminate the conspiracy until the co-conspirators received their payment. And it cites to United States versus Hickey out of the First Circuit. That's a federal case in 1979. The trial evidence established defendant's connection to those payments. Thus, based on the unique facts of this murder for hire, defendant's case is distinguishable from the Denise Williams case. The court also denies, and by the way, why he's distinguishing it from the Denise Williams case is because in that case, the First District Court of Appeals reversed the murder conviction and only affirmed the conspiracy conviction. So what the judge says by distinguishing it is says that there are additional different facts here that make it different from what happened in that case in the appellate court. And the difference is that there is evidence of her being involved in compensating the killers. The court also denies the renewed motion for judgment of acquittal, relying on its denial of defendant's initial motion for judgment of acquittal. All direct and circumstantial evidence admitted, and evidence demonstrating defendant's consciousness of guilt. Her flight to Vietnam, her efforts to change the testimony, or elicit testimony from jailmates to try to destroy the value of this case, destroy the testimony of Catherine McManua, all go into the consciousness of guilt as well, right? Okay, let's get back to reading. B, decision of any matter of law which arose during the trial. The court does not find error in refusing to admit the complete 2014 and 2023 planners. The state introduced particular entries from the two calendars. The defendant asked to introduce the complete calendars during his case in chief. As an initial matter, the request was untimely under section 90.108-1 Florida statutes. Then it quotes, although the plain language of the statute requires the adverse party to introduce the other part of the statement at the time that the first party introduces the statement, Florida courts have generally allowed the adverse party to delay introducing the other part of the statement until cross-examination. Okay, so that has to do with the rule of completeness, right? So if you're gonna, for example, take something out of a document or out of a transcript or out of an answer in a deposition, but you're not presenting the entire thing. Like, so this, let's say the state of Florida is presenting a portion of something, and here it was a portion of the 2014 or the 2023 calendar. And the defense feels like, hey, wait a second, you're taking things out of context. If you look at the rest of the stuff, then you'll see the full context and you can understand it better. So the defense has two options, according to this case that the judge cited, right? They can immediately say, judge, rule of completeness, objection, rule of completeness, where they want the jury to see the entire calendar. Or in the cross-examination, they can bring up other portions, for example, of the 2014 and 2023 calendars that would demonstrate that whatever the state was trying to argue from that one piece or the two pieces that were introduced were inaccurate or were being presented out of context, or in other words, let's back up for a second, right? So let's give you an example. 2014 calendar, they used it to show that in the back pages, there was information about Dan Markel's car and tag number, kind of hinting at the fact that Donna Adelson may have provided that information to the killers, right? If there is something else in the 2014 calendar, as it appears that the defense team was trying to get at during the closing arguments and the judge shut them down, saying this is too late. So if there was something else, in the 2014 calendar that would have shown that implication by the state that this was there so that it could be provided to the killers, but there's something else in this calendar that shows this to be a completely innocent act, the time for the defense to have done that would have been when the state of Florida was questioning whoever was the witness on the witness stand, talking about the calendar and introducing portions of the 2014 or 2023 calendars. So either immediately saying, hey, rule of completeness, objection, or during the cross-examination, bringing out the parts that would diminish the value that the state was trying to get out of this particular portion of the calendar. So in essence, the judge writes, the defendant's request was too late because it came after cross-examination of the relevant witnesses. Even if the request was timely, it was improper because the purpose of the rule of completeness is to avoid the potential for creating misleading impressions by taking statements out of context. Citing to the Larzellari case, which we have discussed before, maybe we were talking about the conflict of interest issue, but this case came up before. By its very nature, a calendar/day planner is divided into a series of pages corresponding with days in a year. Thus, the court concludes the entries the state admitted into evidence were not out of context. They were not one part of a whole. There were specific dates in the calendars referencing specific events, and those relevant entries were admitted in their entirety. Interpreting the rule of completeness to allow for every other entry in the calendars would require the contemporaneous admission of any written or recorded statement that might cast light on an admitted statement. Using the language of section 90.108(1), fairness does not require turning a trial into a voyage on a sea of hearsay. That's a nice quote, citing Carter versus State from the 4th DCA in 2017. Accordingly, defendant's invocation of the rule of completeness was properly denied. And by the way, I'm doing this live right now, where instead I was about to publish a 6th installment on the interview that I did with Detective Craig Isom, who's retired, of course, where he watched the videos that I published, and then he asked me, hey, there was one good question you asked me that I refused to answer. How come you cut it out? And I said, well, I don't know. I just, since you said you don't want to answer it, I figured I would cut it out. I said, I don't mind if you put it in. So I actually went and found where that was, and I created a new video where it has my question. It is about Wendy Adelson. So I have a question for him. It's a very detailed question, and then he refuses to answer it. And then after that, I put the section of the police interview of Wendy Adelson where she's interacting with Jane McPherson. So that was the video that was supposed to be playing now, but because I saw that the order denying the post-trial motions was entered, I said, wait a second. This is more important. This is urgent news. So I'm doing this instead. But I'm planning to publish that video with that question that Craig Isom refused to answer. And it's not the only one. There are many questions that he decided not to talk about because he's trying to preserve any potential cases if there is more. But I'll publish that soon. All right, anyway. All right, let me continue reading. Sorry for the interruption. Accordingly, defendant's invocation of the rule of completeness was properly denied. Moreover, the court permitted defendant to use the entire set of calendar entries as a demonstrative exhibit during her closing argument, and defendant argued the state did not want the jury to see them. And defendant argued the state did not want the jury to see them. Oh, I see. So during the closing argument, I guess Jackie Fulford must have said, hey, look, here's the rest of the calendar, and the state didn't want you to see that, like they're hiding stuff, right? Or they're trying to mislead you. In addition, the 2023 calendar entries defendant sought to admit would not rebut arguments that she was fleeing to avoid prosecution when compared to the vast amount of contrary evidence that existed beyond the planner, such as inter alia, defendant's text messages, WhatsApp messages, Google searches for non-extradition countries, recorded conversations, emergency fast-track visa, and one-way ticket to Vietnam. This judge is on top of it, as you can tell. All right, and then C, I guess the final, is it the final one? Maybe the final argument on the motion for new trial, where for other cause, let's see. The court does not find the arguments presented in this claim warrant a new trial, specifically addressing defendant's decision not to testify. Oh yeah, there was a whole issue in the motion for new trial about the fact that Donna Adelson needed more time to decide whether or not to testify. And I haven't read this portion yet, so what I'm going to say is based on my thoughts and my analysis before. So she was arguing that she needed more time to decide whether or not to testify. The arguments from her attorneys included the fact that supposedly the state had changed some of the evidence and that there was a ton of evidence that they didn't expect, I guess. And one of the points that I raised was, hey, they could have asked for a continuance. They did kind of argue that she needed more time, but they didn't really vociferously ask for example, a one-day continuance or anything of that sort. But let's see how the judge is going to look at this. All right, this is interesting. Let me start from the beginning. The court does not find the arguments presented in this claim warrant a new trial, specifically addressing defendant's decision not to testify. Oh, and the other thing I pointed out is I didn't even see in the motion, and maybe it was there, but I missed it, but I didn't even see them saying that afterwards she decided that she would have testified, which I would think should have been included there. But anyway, let's read again from the beginning. The court does not find that the arguments presented in this claim warrant a new trial, specifically addressing defendant's decision not to testify. The court relies on the trial record. After defendant had closed her case, but prior to the commencement of closing arguments, the parties were asked to approach at sidebar. Oh, we have attachment C, the sidebar. Maybe I'll read that too. The court explained that it had performed additional research and wanted to confirm that defendant did not want to testify. Attachment C. And then talks about this case that the judge had found, Gibson versus State. The court added, the reason why I'm bringing this issue to the party's attention is only because I believe the appellate cases of this state make clear, prior to instructions in closing, the exercise of the fundamental right leans towards allowing the defendant to reopen her case if she wanted to testify. Okay, good. So I guess the judge showed a willingness, and this is something that I didn't even know because we had no access to the sidebars. So the judge actually did some research about it when they started to complain, and even offered apparently the opportunity for the defense to reopen the case and allow her to testify. Upon the court's inquiry, counsel responded, we talked to her for a somewhat lengthy period of time last night over the phone while we were preparing. She informed Ms. Fulford and my paralegal that she felt secure in her decision. We're going to definitely read attachment C. I hope I have it. It should be there, yes. Defendant was then placed under oath and asked if she was absolutely firm about this decision not to testify. Did I just mess up? Yeah, I did. What did I do? Sorry, let me go back there again. Defendant was then placed under oath and asked if she was absolutely firm about this decision not to testify. Defendant twice responded, yes, I am, but asked for a few minutes to talk to counsel. The court then granted an additional 30 minutes to further discuss her decision. After that time had elapsed, defendant once again stated, I've made a decision, I'm not going to testify. When asked if she was firm on this decision, defendant answered, I am. The court concluded, I will make no further inquiry unless the state or the defense seeks for the court to do so at this point. Neither party did. So basically, the judge was giving the defense all the opportunities, like if they really, really, really wanted to reconsider further, he would probably let them do it. Nobody asked for more time. Let's read footnote 1. The court also clarified that its reference to contempt was related to defense counsel not timely returning from their conferral with defendant the previous day after being instructed they had exactly 5 additional minutes to discuss defendant's decision not to testify. Defendant and counsel did not seek any additional clarification on the matter. For additional context, the court attaches a compilation of the discussions concerning defendant's decision not to testify that precipitated the court's warning, including when the court mentioned that whether the direct examination will start this afternoon is a separate matter from whether she is planning to testify. Okay, so yeah, the other issue, by the way, that they had raised was the fact that the allegation that the judge was unfair towards the defense counsel, and Donna Adelson. So we'll see if the judge addresses that at all here. I guess he didn't. Accordingly, the defendant was provided sufficient time to and did make a knowing, voluntary, and intelligent decision not to testify. In denying defendant's other allegations, the court relies on the complete trial record of the proceedings. Okay, so that's the only sentence that he says about, I guess, the issue of fairness or his lack of fairness. He says, hey, look at the entire record. It will show that I was 100% fair. And that's all he says. It is a court order and a judge that the defendant's motion for leave to interview jurors, motion for new trial, and renewed motion for judgment of acquittal are denied. So let's see Exhibit C. Okay, so this is all about the jurors. I don't care so much about that. Let's see about the interesting one is C. So let's see. This is Exhibit B. Here's C. All right, let's read the sidebar. This is going to be interesting. It may be very long. I don't know how long it's going to be. So I'm on page 19. I hope it's not going to go all the way to 57, but it might. Yeah, this is very long. I don't know if I'm going to be able to do all this. Oh, there's something else. All right, let's go to page 19. I'm just going to start reading through it. I want to find the part that is this sidebar. So since I'm doing this live and I haven't read this before, this is just hot off the press. Okay, this is the part. All right, let's read this. Okay. This is a sidebar, something that none of us got to watch. So this is Judge Everett. In researching some matters last night in anticipation of moving into closing today, I did want to confirm with the defense that the defendant is not asking to testify. Mr. Zellman. We talked to her for a somewhat lengthy period of time last night over the phone while we were preparing. She informed Ms. Fulford and my paralegal they had taken her off speakerphone at that point, that she felt secure in her decision. If Your Honor would like to have Mrs. Adelson come to the bench, I could have her, the court. Just have the bailiff bring her over here to the sidebar. Mr. Zellman, yes, sir. The court. Mrs. Adelson, before we move into instruction on the law and the closing arguments this morning, I once again wanted to confirm with you that you are firm in your decision that you are choosing not to testify. Donna Adelson. Yes, Your Honor, I am. The court. You are absolutely firm about this decision? The defendant, Donna. Yes, I am. The court. Is there anything further that you need to speak with your 2 attorneys about on this matter? Donna. I would like a few minutes to talk to them. Yes, if I could. The court. As to this particular decision or some other matter? Donna. As to this particular decision. The court. On this, I will provide a few moments After this, we do need to resume timely. Yesterday, when the court made reference to contempt, this concern has continued to occur and also not returning from the conferrals. We need to resume court. So, as he explained in that footnote earlier, this comment was about them taking way too long, like about the attorneys not 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 complying with the timing issues. So, if you need to speak to your attorneys now concerning whether you wish to testify, I will allow you to do so. I'm going to give you 10 minutes to accomplish this. When 10 minutes is up, we do need to move on. Ms. Kappelman, Judge, is it your intent to go right into instructions and closing at the conclusion of the 10 minutes? The court, that would be my intent. Ms. Kappelman, I would request 30 minutes because I need some more time to get my closing act together. So maybe that can give a little more time for the defense to do what they need to do as well. Both parties need to share their closing PowerPoints and demonstratives with each other too. The court, okay, we'll take it 30 minutes then. The reason why I'm bringing this issue to the party's attention is only because I believe the appellate cases of the state make clear prior to instructions and closing a request to reopen the case or for the defendant to testify, the exercise of the fundamental right leans towards allowing this to occur. I'm giving her this last opportunity to confirm with counsel and make this decision. Ms. Fulford, may I say something, Your Honor? After the state is done with their closing, we're going to need a break for time to set up our stuff. The court, that's fine. Will any recordings be used as part of the closing today? Ms. Fulford, yes. Ms. Dugan, may I ask for one more thing? Is it the court's intent to read the stipulation prior to jury instructions? The court, yes, because that will be a part of the evidence in the case. All right. The court, before we bring the jurors in, so this is already, sidebar is concluded, and the judge is talking to everyone. All right, so this we all saw. Then the court went in recess. And they're talking about an instruction. So this is all about a jury instruction. Okay, now here's another sidebar with the defendant present. Just so all the parties were clear on what was just discussed concerning the jury instructions, with there being no lesser included offenses that will be considered by the jury, the second and third paragraphs of the introduction will be removed, and the second sentence in the third paragraph will be removed. Concerning the other matter that previously came up during the sidebar, Mrs. Adelson, you remain under oath as to whether you wish to exercise your right to testify in this trial. Have you made a decision considering this? Donna, I have made a decision. The court, what is that decision? Donna, I'm not going to testify. Judge Everett, you're firm on this decision? You are firm on your decision? Donna, I am. Judge Everett, very well. I will make no further inquiry unless the state or the defense seeks for the court to do so at this point. And I guess what he means by that is, like, should he go through the whole colloquy about the rights and all the stuff? And neither party requested for the judge to revisit the entire issue with Donna right there. That's what he means. So the court, the colloquy on the subject matter is united through the multiple discussions that occurred the previous day of trial on this day as well. Okay, so yeah, that's what he's saying, and then I understand what he means. So what he means is that he did a full colloquy with Donna in the trial on the previous day. So the previous day, that's when he asked her. First, they were saying, no, we need more time, so on and so forth. And then they discussed, and then they didn't come back on time. Eventually, they come back. And then the judge did a full inquiry with Donna about whether she was going to testify. And in the end, she says she's not going to testify. So then we go overnight, because then they decided that the jury instructions and closing arguments would happen the next day. So she had this extra night to rethink it. They discussed it some more. Her defense attorney, Jackie Fulford, and Zellman's paralegal were talking to Donna. She thought about it some more, and she still decided not to testify. Then the next morning comes in. The judge had done some research, said, look, I'm going to give you, because you kind of hinted at the fact that you needed more time and you didn't have enough time. I'm telling you, if you guys want to reopen the defense case and have her testify, I'll allow it to happen. Okay? You just got to ask. So Zellman says, okay, well, we talked to her about it and she doesn't want to. And the judge was even extra careful. He says, okay, well, let's bring her in here. Let's ask her some questions about it. So they did a limited inquiry with her, just about whether she had reconsidered, had thought about it some more, and whether she had a firm decision not to testify. And she responded, I'm not going to testify, and that she was firm. And then she asked for an additional time. The judge gave her 10 minutes at first, but then because the prosecution wanted a little more time to prepare their closing, she got an extra 30 minutes to think about it. Then she comes back. The judge asks her about it. She's firm on her decision. So another waste of paper, in other words, right? I mean, and furthermore, I didn't even see in the motion for new trial whether she says that she would testify. She would have. But anyway, that's the bottom line. So now I think I'm done reading the relevant portions of this. I don't believe that the rest is that important. Let me just take a quick look. So this is about other issues. Okay, I think that's enough about the reading. So I'm done with the reading, and I guess I'll take a couple of questions or a few questions. It is getting close to the time that I'm supposed to do something. I'm at home today, so I'm doing this from home. So I'm not going to go scroll back, and I apologize for that. Thanks, Rebecca Hanna, for becoming a new member. So I'm not going to go all the way back, but if you guys want to ask a question, ask it now. Because now I'm looking at the chat. I'm not looking at the transcript. So you have your moments to ask a question. Go ahead. And if you don't have a question, then this video will be over soon. ML, will Donna and Charlie be able to write each other? I don't see why not. I mean, yeah, why not? But all communications from prison are, they can be reviewed by the prison guards, by the prison authorities. So obviously they cannot write each other to try to change testimony and stuff like that, because that would be seen and there would be copies of everything. So, all right. And yeah, hey, Skeeter, nice to see you. I'm sorry to hear about that situation that you mentioned. Thank you so much, Skeeter. Questions? Hey, Enzo, chill out. Are the Donna calls post-conviction available yet? They will not be available unless the state of Florida finds evidentiary value in them and submits them in discovery, in this case or in any other subsequent case. So, for example, if new charges are filed against somebody and there's information there that is relevant to that case, then it would be. But in general, those conversations are private unless they become evidentiary. They have an evidentiary value, like it was with the situation of the revelation that these people were planning to flee to Vietnam. Can Donna ask for death penalty? No, she cannot. Do you think they would consider, so Scott, do you think they would consider a charge of accessory for Wendy, something lesser, but with teeth? I would have to look at the statute of limitations. I would assume that it has expired, unless, of course, they can allege something that happened more recently in furtherance of the conspiracy. And of course, we know that Wendy did help some, right? Like we know, for example, there's a recording of Donna saying that Wendy was getting information from her employer, the judge, the federal judge that she worked for, and apparently was sharing that information with Donna. Not sure if she was sharing it or not. I'm assuming that if the judge revealed anything, it was in confidence, assuming that his law clerk wouldn't share that information with anyone else, especially the alleged co-conspirators. But I'll leave that for the prosecutors. But could she, if it is within the statute of limitations, they could charge her with something less, yes. Hello, Judy, nice to see you. You're welcome about the Detective Isom interview. And like I said, I'm going to do a very short episode 6 with that one question about Wendy Adelson that he refused to answer. Thank you, Paris. Appreciate that comment. Oh, what kind of dog do I have? I might show him. Enzo, come here. He's a mini poodle. I have a mini poodle. Come here, boy. Enzo, come here, boy. I'll show you Enzo. Come here, boy. Come on. Come on, you're going to be a superstar. Here's Enzo. That's Enzo. That's our cutie pie. Such a sweet boy. What a good question from Debbie. That's Enzo. So sweet. Smells good too. All right. All right, you can go do your thing. Go guard the front door. Bark if anybody shows up. Yes, sir. Yes, sir. All right. What's next? Enzo, you're famous. Is there any chatter about either Harvey or Wendy? If there was chatter, I don't distribute chatter. So no, I don't talk about things like that. All right. Could the state, Yak Club, could the state indict Wendy on perjury and then rescind her immunity? That is a very interesting question, a very good question. There are different thoughts on that issue. There is a thought that the only thing that you can do once you give somebody the immunity is to charge them with perjury if they lie, if you can prove that they lied. But that doesn't eliminate the immunity. But there's an argument to be made that the perjury eliminates immunity. That's something that Georgia Kaplan herself hinted at in a prior interview. So I think it's an argument that can be made, and that's all I can tell you right now. It's not clear, and there may be different authorities that look at it differently. Ms. Lady, do you know if Wendy changed her name? She seems to like to change names. No, I don't know that. Thank you for the nice comments about the interview with Detective Isom. And for the compliments for Enzo. Enzo, you're getting compliments. He's very handsome. Mini poodle. I just messed up. Cecilia, do you think Donna will write a book? If so, can Markel sue for her for the profit, donate to? I think she could write a book, but I don't see why she would. And she already has money, and the Markels are not suing her for money. So I don't think the Markels are interested in suing anybody for money. I think that they're just interested in having everybody who was involved be in prison, and that's it. Why wouldn't they be able to call her current boyfriend to see whether she confessed? But she wouldn't confess to anybody. So anyway, maybe she would. Thank you so much. Thank you so much. Coming after us. I don't know what you mean by that, but you come after him, you come after us. Okay, well, maybe. I come after everybody. I'm just trying to protect. Guys, it's very simple. The moment that this becomes unprofitable because other channels are doing reaction videos, and we were close to that at the Donna Adelson trial, I'm just not going to do it anymore. It's your choice. Then they're not going to have any. I guess they will still take someone else's stream and whatever. It doesn't matter. So, all right, guys, I got to get going. But it is your choice. If you want to support the people that put the money in, I mean, I super support. Watch it on Court TV. They actually put on a full 5 people were working there: producer, camera people. I mean, it was like a full production, 2 cameras, amazing. We'll go watch it on Court TV. All right, thanks everybody. Have a good one. Bye-bye.
Very serious.